Sir Eli, Sir Daniel, my ladies, Your Excellencies, friends, colleagues, ladies and gentlemen. On behalf of Mena Chambers, it is with great pleasure that I welcome you all on this beautiful November day to this inaugural lecture on the Sir Elihu Lauterpacht lecture series on the administration of international justice. I am particularly delighted that Lady Lauterpacht has graciously agreed to accompany Sir Eli in order to be with us here today. I had to think very hard to speak of Sir Eli's career and significant contributions to international law would require a whole lecture in itself. Sir Eli has excelled in his double role of practitioner and scholar, of doer and teacher. This is a rare combination at the best of times, and particularly rare in this instance. I, like many others, owe Sir Eli a huge personal and professional debt. To me, to all of us, he has been a professional exemplar and pedagogic role model, both as personal mentor and a professional guiding light. I hesitate to recall precisely how many years it's been since I've known Sir Eli. I think we may be in the second decade of our relationship, which is saying something. But during all that time, he has never failed to give advice when asked, or to assist when his assistance was needed, or indeed to help in making vital professional contacts in those early days. Now, the main aim of Sir Elihu Lauterpacht lecture series is therefore to pay tribute to one of the greatest scholars and practitioners of international law of our time. I am profoundly grateful to Sir Eli for agreeing to have these lectures named after him, naturally with some hesitation at the beginning. And I'm sure that he will join me in thanking him for being with us today as we celebrate his work, achievements, and indeed, friendship. I'm not finished yet. I'm equally delighted that Sir Daniel Bethlehem was swift in agreeing to give the inaugural lecture. There is, in my view, no better person to launch this series. Sir Daniel is a prolific lawyer. He has appeared before many courts and tribunals, including the International Court of Justice and the European Court of Justice. He has also been a prominent academic at the LSE and Cambridge, where he was the previous director of the Lauterpacht Center. He tells me today that he is also a lecturer at Columbia University. And he recently served as the principal legal advisor of the Foreign and Commonwealth Office of the United Kingdom to some Ministry of Foreign Affairs. I have had the honor of working with Sir Daniel in a couple of international cases. Not only is Daniel an astute lawyer, but he is also a genuine pleasure to work with. I'm not sure if we can say the same about all lawyers, or indeed lawyers in general. We are therefore privileged to have Sir Daniel with us, and he has, in typical fashion, came up with an intriguing topic entitled The End of Geography, the changing nature of the international system and the challenge to international law. I don't need to remind such a learned audience of how important and topical the subject matter of this lecture series is. As Sir Daniel will doubtless illustrate, the administration of international justice remains at the forefront of efforts by the global community to lay down workable and reliable structures of governance by which peace and cooperation between states and non-state actors can be made, and made to endure. Now, before I hand over to Sir Daniel, I have a couple of announcements to make. First, Sir Daniel has kindly agreed to take a few questions at the end of his presentation. After the Q&A session, we will have a surprise for you, I hope, and that's the unveiling of a specially commissioned portrait of Sir Elihu by a prominent Belgian artist, Mr. Frederick Wagemans, after which Sir Elihu will say a few words to us in conclusion. Without further ado, may I ask Sir Daniel Bethlehem to deliver the inaugural lecture of the Sir Elihu Lauterpacht lecture series on the administration of international justice. Sir Daniel.
The speakers. Yes, yes, yes. But Adnan was talking this way. Well, ladies and gentlemen, Adnan, Eli, our celebrant, Kathy, other honoured guests. Adnan had lapses of memories about precisely how long we've all known each other. I'm going to refresh you all. So there's not going to be any, as it were, discrete veils drawn over long periods of time which we all have known each other. I hope you can hear me. I know that it's echoing a little bit, but if you can't, do shout. It's a very great pleasure and privilege to be here at this gathering of friends to inaugurate this lecture series in Eli's honour. Adnan, thank you for the invitation and for your warm and generous words. We were both and remain students of Eli's, owing, as you've said, more to him in both scholarship and friendship than we could ever say. You and I recall very precisely when we met. It was in late December 1988, 25th of December 1988 to be precise, around Eli and Kathy's lunch table. You know the date. The rest is history. I value very greatly our enduring friendship and our shared calling for international law. It's a real delight to see you so deservedly successful in your setting of Mena chambers, and to be able to play a small part in this tribute to Eli that you have inaugurated with this most auspicious lecture series. Eli, you know, or if you don't, you ought to know, of the warmth and the immeasurable regard in which you are held by all of those who have the privilege to know you, as a friend, as a colleague, as a student, as a courtroom opponent, as a dining partner, and more. With Kathy alongside and other members of the Lauterpacht family, you have drawn us, so many of us, into a magic circle of charm and hospitality, of intellectual vigor, and of an endeavor of law that has become for us all, the many thousands of students over the years, that has become for us all a calling, a pursuit of life in the law. I think unlike other areas of law, no one falls by dint of circumstance or by happenstance of a case referred into the practice or the teaching of international law. International law is chosen, and chosen so often, and certainly in this case, by those who've come under your spell because of the inspiration conveyed by a teacher and a guide. Friend, teacher, mentor, this is a wonderful occasion, and I'm honored to be here. Well, ladies and gentlemen, let me turn to my topic, chosen with a degree of provocation: the end of geography, the changing nature of the international system, and the challenge to international law. The topic is not self-evidently about the administration of international justice, which was the title of Eli's 1991 book in the lecture series in memory of his father, the Lauterpacht Memorial Series of Lectures and Monograph, which now also carries the name of this lecture series. That book was and remains an influential book about aspects of the settlement of international disputes. My topic is not about the settlement of disputes or about the administration of international justice, but it has connections with Eli nonetheless, for at least two reasons. First of all, at a practical level, it was from Eli that I learned about the geography of international law, about boundary disputes, about the stuff of states, about maps, and ultimately about the subjects of the law. I was captivated from the very first moment of tramping over a far-flung stretch of desert on which had been drawn a colonial line in the sand, across which wars had been fought, but which was then, at that particular point, to be the subject of a peace negotiation that had the object of making visible the delimitation of that previously uncertain line for all to see, and for the wider purpose of enabling the peoples on each side of that line to move on and to live their lives in peace. The second connection of the topic to Eli that I would like to speak on this afternoon is about the system of international law, about aspects of its origins and its character, and about some of the challenges that present themselves for the future. This is an inquiry that is quintessentially Eli's, whether as a scholar or practitioner, as an advocate or as a judge. A sense of the system of international law and of its contours, and of the role and place of international law in the international system more generally, has been an ever-present theme. This being said, and this gave me a fleeting moment of pleasure, I have to admit, notice of the title of this lecture, which Adnan and his colleagues have so assiduously sent out into the ether, has been a cause of some expressed concern around the world. On hearing of it, Victor Prescott, the notable geographer from Melbourne University and author of a number of important works on boundaries and frontiers, felt sufficiently concerned by the title to email Barbara Kwiatkowska to affirm that, and I quote from Victor's email, "With very great respect, I must advise that the study of geography will continue into the indefinite future." My work was done. Barbara, also an expert on boundary matters, when circulating Victor Prescott's email, professed herself to be equally shocked by the provocative title. And in the nature of such authoritative polling, I anticipate that there will be many others out there who will be waiting, either in readiness and with resolve, to challenge whatever dangerous thesis may be advanced, or alternatively, to flee to high ground as the uncontoured, lawless topography of the future sweeps over the land. Now, there may, of course, be reasons for such concern. This has happened before. We read in the book of Genesis that God saw humankind's evil doing on the earth and determined to correct this, that he brought a deluge upon the earth for 40 days and 40 nights, such that all high mountains that were under all the heavens were covered. Perhaps we should be concerned about a revisitation of this kind. But I come here today not as a meteorologist with dire climatic predictions, but as a lawyer with an inclination to test the resilience of the Westphalian legal order. For it is a world that rests very heavily on geography. And the question I would pose is whether this prism through which, despite protestations to the contrary, we continue to see the international system, whether this prism is an appropriate controlling vision of international law as we move further into the 21st century. So, to Victor and to Barbara and to others, I do not come here to predict the end of geography. The discipline will remain and flourish even for lawyers, and especially for those engaged in boundary disputes. I should add that my choice of title is not so much inspired by Francis Fukuyama's The End of History and the Last Man, with its vision of apotheosis at the end of the Cold War, as it was inspired by Thomas Friedman's The World is Flat, the globalized world in the 21st century. The issues I would address are those of globalization, the changing nature of the international system, and whether international law as we know it is fit for purpose in a world that, to use Thomas Friedman's language, has moved from globalization 1.0 of its state-driven origins through globalization 2.0, where the key agents of change were multinational corporations, to globalization 3.0, the world in which we now find ourselves. This is a world, as Friedman proposes, in which, and I quote from him, the force that gives this period, our time, its unique character, is the newfound power of individuals to collaborate and to compete globally. This lecture might have been subtitled, "The World Looks Different from Geneva than it does from New York." There are dueling visions of the international system. By New York, I mean the New York of the United Nations, of the General Assembly and the Security Council, rooted in states, in sovereignty and equality, in notions of domestic jurisdiction and non-intervention, in boundaries, in majority votes and vetoes, in hard power, soft power, and smart power, but power nonetheless, in geographic blocks, in persuasion, in regional influence. This is classic Westphalia, albeit in a contemporary institutional setting. There is a different vision of the world from Geneva. By Geneva, I mean the world of the UN specialized agencies and other similar organizations, not all of which are based in Geneva, but the shorthand will suffice. Here, while still rooted in states, the world looks different. Big power politics is less frequently in evidence. Cooperation across boundaries and despite them is the modus operandi. The focus is technical, on climate, health, migration, telecommunications, trade, transport, travel, and more. The international system looks very different when seen through the lens of the specialized agencies and similar organizations than it does through the lens of the General Assembly and the Security Council. The websites of the World Health Organization and the Food and Agricultural Organization, of the International Civil Aviation Organization and the International Maritime Organization, of the World Trade Organization and the International Telecommunications Union, of the UN High Commission for Refugees and the International Organization for Migration. These websites paint a very different picture of the international system and of the challenges faced by international law than that which is visible when we look through the New York Westphalian prism. These agencies and organizations are at the sharp end of the world of the future, focused on cyber, on food security, on pandemic health scares, on the interconnectedness of the global trade and financial system. These two worlds, New York and Geneva, intersect, of course, but their vantage points and prisms are very different. And this is even before we get to the vastly more diffuse and decentralized world that Thomas Friedman describes, in which the actors of influence are individuals and corporations engaged internationally under an umbrella of international or transnational law that is, for all practical purposes, increasingly remote and increasingly detached from states. The US National Intelligence Council is very shortly to publish a long-awaited report entitled Global Trends 2030 as part of its endeavor to inform the new Obama administration about what the world could look like in the future. It publishes this global trend report at the point of the incoming of each new administration to take a peek into the future. As part of the process of preparing this report, there has, over recent months, been an extensive series of public discussions on a wide range of topics, from the role of the US in a multipolar world to the impact of Chinese economic growth, the proliferation of advanced technologies to small and regional non-state actors, future trajectories of migration, and more. Initiating the online dialogue on these and other issues, Myron Brilliant, the Senior Vice President for International Affairs at the US Chamber of Commerce, published an essay entitled "The World in 2030, Are We on the Path to Convergence or Divergence?" His essay opened as follows, and I quote, "For much of the last 50 years, the international system, its structure, operations and goals of its key institutions remained remarkably stable. Now all that is changing. The international system as we know it today, and as represented by such organizations as the International Monetary Fund, the World Bank, the World Trade Organization, the World Health Organization, the OECD, the United Nations and NATO, has to reform, or the institutions at the core of the system will become marginalized or even obsolete. Moreover, we should expect new institutions to develop that will contribute to a reshaping of the global landscape, with profound implications for America and for the Western world in geopolitical, security, and economic terms." And he goes on to say that the change will be more evolutionary than revolutionary, but it will be significant. This is the glimpse of the horizon that I would like to explore from the perspective of international law. International law is the glue that holds the international system together and defines and shapes the space within which those who are subject to the law operate. There is considerable discussion about the shape of the international system over the next 30 to 50 years. There is not, however, the same robust review of the international legal system. It is wise and it is necessary that we, the College of International Lawyers, begin to consider these issues more closely. Against this background, let me take a step back a little to describe in broad brush terms where we have come from and aspects of our trajectory into the future that will inform the comments that follow. Elements of international law, of course, have their roots deep in antiquity and in the principles and practice of the Middle Ages. International law as we know it today, however, as a systemic body of rules, has its intellectual origins in the writings of the Dutch jurist Hugo de Grotius in the early 17th century, with works on the law of capture, on freedom of the seas, and his seminal treatise of 1625 on the law of war and peace, the Jure Belleac Packets. This, as Sir Hersch Lauterpacht was later to describe it, became the foundation for all later developments in the field of international law. It remains the intellectual font for international law as currently conceived. In parallel with the developments of this intellectual tradition was the emergence of the system of sovereign nation states, ready to avail itself of these developing principles of law. The peace treaties of Osnabrück and of Munster, signed respectively in May and October 1648, which brought to an end the 30 years and the 80 years war under the Peace of Westphalia, resulted in the redrawing of political boundaries in Central Europe. It also resulted in the recognition of the rights of each sovereign prince to determine the internal elements of his state. And so was born the Westphalian system of interstate law, a system of competing and interacting sovereign entities whose discourse and interaction was to be regulated by law. Adnan, Eli, distinguished guests, geography was and has remained to this day central to this system of law. Sovereignty and the equality that flows from it rests fundamentally on the notion of the exclusive authority over discrete parcels of territory. Independence, described by the Permanent Court of International Justice in the Austro-German Customs Union case as the sole right of decision in all matters economic, political, financial, or other. Independence hinges on the ability to exercise such authority within the frontiers of a state. The very concept of statehood as later expressed in the Montevideo Convention on the Rights and Duties of States of 1933, is rooted on a nexus between a defined territory and a permanent population, a government, and the capacity to enter into international relations. Beyond these essential elements of a state, other concepts and principles of international law are also deeply rooted in traditional notions of territorial geography. The principles at the heart of the Charter of the United Nations include the sovereign equality of UN members in Article 2.1, the prohibition on the threat or use of force against the territorial integrity or political independence of any state in Article 2.4, and the reserved domain of domestic jurisdiction into which intervention is not permitted. All of these are deeply rooted in the geography of states. Flowing from sovereignty also comes the principle of state jurisdiction, that is, the power of a state under international law to govern persons and property by its municipal law. Jurisdiction, although it has non-territorial dimensions, is largely manifest in territorial terms. Indeed, the territoriality, nationality, passive personality, and protective bases of jurisdiction, as well as notions of extraterritorial jurisdiction, are all hinged to a greater or lesser extent on geographic linkages, affiliations, and effects. Regulation, accountability, and the income-raising authority of states through taxation are also largely, even if not exclusively, rooted in the geographic and tangible reach of a state. So geography stands at the very core of our contemporary international legal order, and it is everywhere deeply embedded in the most fundamental principles of our legal system. Now, it's no part of my thesis today that states are on the verge of disappearing, or that these traditional principles rooted in geography that stand at the heart of the system of international law are withering away. On the contrary, we see everywhere an inclination towards independence and an assertion of sovereign rights over territory in South Sudan and Kosovo, by the Palestinians and in Somaliland, by separatists in Quebec and in Scotland. Borders and title to territory continue to matter, as we see in the South China Sea, with competing claims to the maritime space and to the islands by China, the Philippines, Vietnam, Malaysia, and Brunei. There are live territorial and boundary disputes in every part of the world, from Chile and Peru and Belize and Guatemala in South and Central America, to those in Africa, such as that concerning Morocco's claims of Western Sahara, or between Malawi and Tanzania over the waters of Lake Malawi, in the Middle East between Israel and Syria, or in Asia, for example, between India and Pakistan over Kashmir, or between China and Japan over the Senkaku Diaoyu Islands. Issues of geography remain vital and fundamental in all of these matters, and will be so for the foreseeable future, driven by both national aspirations and claims to natural resources. The geography of statehood, the physical space of a state, the extent of its territory, its topography, will also continue to be important determinants of its comparative advantage in the economic sphere. The emerging power of the BRICS in the global economy, of Brazil, Russia, India, and China, is not happenstance. In addition to their developing industrial base and sizable population, it derives from their vast territories. These four countries make up over a quarter of the world's landmass, and with geographical extent invariably comes also natural resource riches. So geography is hugely important to power, both economic and political, and will remain so. But, there had to be a but, and this is my thesis today. This systemic continuity is only part, and an increasingly small part of the picture. While the geography of statehood is likely to remain at the root of the international system, it is becoming increasingly less important as people, goods, services, and funds flow across borders, as individuals and corporations engage directly with one another without the intermediation of states and their paraphernalia. As virtual space takes on dimensions and an importance that rivals physical space in the world of transactions, communications, and engagements. As regional and multilateral integration arrangements between states reduces the importance of boundaries, and as international and non-governmental organizations proliferate and operate transnationally on the basis of technical mandates that transcend or endeavor to transcend narrow sovereign rights. On this vision of international society, sovereignty and boundaries are like rocks in a river. They may impede the flow and perhaps even on occasion dam up the water. More usually, however, they simply act as an impediment to the directionality of the flow of the water, which eventually finds a new pathway on its free-flowing gravitational course. Let me give you a few tangible examples of the developments that suggest that we may want to look at the geography of international law a little differently. In the period since the end of the Cold War, the world's population has grown by over 1.5 billion people, about 82% of whom were born into the developing world. Over the next 40 years, the current population of around 7 billion is set to grow by a further 2.2 billion, to reach 9.2 billion people. Population growth does not, of course, of itself challenge traditional conceptions of the international system rooted in geography, but it leads to consequences that do. For example, there are today some 214 million migrants worldwide, up 43% in real terms on 10 years ago. According to the Geneva-based International Organization for Migration, migration is now more widely distributed across third countries than ever, with a total number of migrants being greater than the fifth most populous country in the world. The remittances of migrants back to their home countries has increased exponentially over the last 10 years, from 2000 to 2010, from $132 billion to $440 billion, an increase of well over 300%. Levels of migration over the next 30 to 40 years are projected to increase dramatically. Considerable numbers of people are also forcibly displaced, both internally and across boundaries. Looking at the movement of people and goods more widely, and to give only one or two illustrative examples, the International Civil Aviation Organization records 750 million international air passenger movements through just the top 25 international airports in 2008. The International Maritime Organization records a doubling in maritime trade volumes by sea, from 4.3 billion tons in 1990 to 8.2 billion tons in 2008. And then we come to the global health scares. The pages of the website of the World Health Organization dealing with health and international travel open with the following statement. I quote, "More than 900 million international journeys are undertaken every year. Global travel on this scale exposes many people to a range of health risks." And the website goes on to provide 16 different disease distribution maps across the world. Amongst these transboundary health risks were the H5N1, the avian flu, and the H1N1 swine flu pandemics, which you will all recall. Given the very high levels of migratory bird movements and of human travel and migration, these risks have preoccupied the World Health Organization and the Food and Agricultural Organization and others. The challenges, not only to human health, but also to animal, plant life and health, are very considerable. Let me give you one real-world example of one of these challenges, arising out of events of 2007, when Indonesia refused to share the strains of the H5N1 avian flu virus that it had gathered following a significant outbreak of the disease with a WHO global influenza surveillance network of laboratories. This network of laboratories gathers strains of viruses from around the world for purposes of manufacturing vaccines. And Indonesia refused to share its virus strains potentially the most important in the network, because it wanted to patent the viruses and address issues of sharing in the context of discussions about financial recompense and questions about vaccine availability. Subsequent WHO discussions were deadlocked for a number of years, causing major consternation out of Geneva. And it was only with a greater realization of shared vulnerabilities that came in the wake of the swine flu outbreak in Mexico that appreciations began to change. Now, my purpose in highlighting this issue is not to make judgments on the matter. It's vastly more complex than the few lines that I have described suggests. But it's simply to highlight the risks and challenges associated with it, and to observe first that this is not a challenge that is well suited to Westphalian solutions. And second, that there is already a very considerable technocratic post-Westphalian world out there that is mostly invisible to many of us. The proposition of the end of geography is, of course, a caricature. But even though it is a caricature, it is intended to pose a serious question. From a vantage point that is still largely rooted in a Westphalian system, are we, the lawyers, seeing the world sufficiently clearly? And is the system of international law with which we are familiar a system still so heavily rooted in notions of territoriality, in sovereignty, in jurisdiction, in regulation and accountability? Is the system of international law adequate to the challenges that we will face? Now, my response here today is to suggest that there is a risk that we are seeing the evolving international system like a passenger on a train that is traveling at considerable speed, such as to blur our vision of the landscape as we look out from the window. From this vantage point and blurred vision, as we attempt to identify the landscape across which we are traveling, we resort to images and recollections from the last station at which we stopped, and we project onto the next point at which we hope to draw breath by reference to the views and the atmospherics of the last stop. And in so doing, there is a real danger as we take stock of the international legal system and attempt to assess its robustness and fitness for purpose in the future, that things will already have moved decisively past us, and we will be caught in a constant cycle of catching up. As we look to the future and consider the shape of the international legal system and its adequacy to meet new challenges, I would highlight 6 broad areas of challenge that have a self-evidently transboundary, geographic defying quality. They are as follows. First of all, the international environment, shared spaces, the atmosphere and the global commons. Second, the movement of people, both forcibly displaced and voluntarily migrant, and the economic and financial flows that go with them. Third, the challenges to human, animal, plant life and health, and to global food security. Fourth, the enormous and increasing growth in global trade and financial flows, and the symbiotic interconnectedness and potential for systemic vulnerability of the global economic system. We've witnessed that at first hand since 2008. Fifth, the dramatic increase in the global use of the electromagnetic sphere and the practical challenges and risks that this presents. And finally, the transboundary challenges to security that have emerged more clearly into the light over the past decade or so, even if they have been with us for longer, from non-state actors that operate across boundaries and beyond the control of states. This is a pretty formidable array of challenges, which in many respects, and certainly in scale, go beyond Westphalian conceptions of society and Westphalian conceptions of international law. While states will continue to be key instruments of international interaction, of lawmaking, of organization, for some time to come, and notions of sovereignty, of jurisdiction and territoriality will continue to inform our approach to new challenges, we will have to move beyond traditional notions of Westphalia if we are to engage effectively and successfully with the challenges to come. Against this background, let me highlight a number of areas of international law and the international legal system that will require creative thinking in the period to come to reflect the diminishing importance of geography. There are 5 that I would identify. First, international organizational reform. Second, reconceiving notions of jurisdiction. Third, lawmaking and legal reform. Fourth, the subjects of international law. And fifth, reconceiving the sources of international law. Before I do so, however, let me return briefly to Thomas Friedman's vision of a flat world, as it has a view of challenges, a view that challenges or ought to challenge our appreciations for the future. Friedman's thesis is about globalization. Through globalization, he suggests, the world is being flattened. Flattening for him is about the greater connectedness and interoperability of people. Individuals have greater access and outreach. Flattening reflects the dramatic increase in personal empowerment as individuals are able to connect with one another directly, without regard to geography, for reasons of commerce, politics, and social engagement. The flat world is a world dominated by individual actors who are able to engage with one another anywhere without the intermediation of states. Friedman's flat world sketches three eras of globalization. The first, which he calls Globalization 1.0, spanned the period 1492 to 1800. It was an era of discovery and the opening up of the world. It was an era of countries and muscles, of power-driven integration. The second era, Globalization 2.0, spanned the period 1800 to 2000. This was an era in which multinational corporations were the principal agents of change. It was an era of technological innovation that witnessed the emergence of the global economy. The third era, Globalization 3.0, is our time, running from 2000 into the future. In this period, the principal agents of change are individuals, with their ability to collaborate and to compete globally without intermediation. It is a period, and these are my words now, in which geography and the structures and the powers of the state are becoming less and less significant. Important elements of geography and of municipal law will remain. Domestic criminal law offences will still be addressed by the state. But the ability and the actuality of individuals engaging across boundaries on the basis of an increasingly globalized legal framework that almost goes unnoticed is quite remarkable. How many of us in this room, I wonder, read through the contracts into which we enter online almost every day when we download some or other software program or music track or film? Very few, if any, I would venture to suggest. We simply click on the button marked, I agree. Who knows what the applicable law is? How many of us give a thought to the multiple jurisdictions that we traverse when we send an email internationally, and the legal edifice of international law and perhaps of multiple municipal laws that are engaged? Internet service providers located in one country routing packets of data through ISPs in another country on the basis of international telecommunications agreements and other legal arrangements that increasingly address conduct in virtual space rather than in geographic space. Now, the skeptics amongst you will immediately say, of course, that this is, or at least mostly, the domain of private international law, of the conflict of laws, that this is not the public international law that we know and love. And at some level, you may be right. My contracts with Google or Microsoft or Apple iTunes, every time I do an internet search or send an email or download a film, will be governed most likely by the law of some or other state of the United States, or of English law, or of Belgian law, or as the case may be. International law, insofar as it is relevant as it always was, because it provides an umbrella or the foundation on which various municipal legal frameworks are grafted. But at least in my view, this is only part, an increasingly small part, of a largely transactional story. The law of nations, in terms of volume and importance, certainly as measured in economic terms, is increasingly being pressed into the service of private actors to facilitate their engagements and transactions. The states may still be the legislators, but they are now only seldom the intended and ultimate subjects of this globalized and globalizing law. as it trickles down and forms into rivers of legal principles that flow around the rocks of territorial sovereignty and national boundaries and independence, that only momentarily cause a diversion in the directionality and the quantum of the engagements that follow. And the question in all of this is whether international law, the law that is our calling, is adequate to the task. Are its still largely Westphalian structures sufficiently nimble to address the flowing river of global interaction? And as we consider these questions, it is interesting to graft onto Friedman's globalization matrix, his globalization 1.0, 2.0, 3.0, the shape of international law. His globalization 1.0, running from 1492 to 1800, the era of discovery, is the era of the origins of international law. It's the era of Grotius and Westphalia. It's the era of states. It is an era of happy concordance between the drivers of globalization and the law that regulated their conduct. What, though, of Friedman's globalization 2.0, running from 1800 to 2000, in which the principal agents of change and integration were corporation? There is, of course, an important body of law that addresses these actors and their transactions. Interestingly, however, this is a still emerging body of law, and emerging largely over quite recent years. The international law on corporate social responsibility, for example, is still a subject in its infancy. Questions remain and are much discussed in lecture halls about whether corporations are properly to be regarded as subjects of international law at all. So as regards this era of Friedman's globalization 2.0, the unavoidable sense is that the Westphalian structures of international law are beginning to lag behind the globalizing international system. And then we turn to our era, globalization 3.0, in which the principal agents of engagement and integration are individuals. Where is international law here? And the answer must surely be that it is a very long way behind all of these real-world developments. There is little international law of any significant effect addressing issues of climate change. The international law and organizational framework dealing with issues of human, animal, and plant life and health is developing at a rapid rate through the technocratic leadership of the World Health Organization. There is more to be done. The international law dealing with cyberspace is in its infancy, even if there is a detailed legal framework that addresses other aspects of the use of the electromagnetic sphere. So these are all issues of substance: cyber, climate change, health, that fall to be addressed at the level of primary rules. We could, for example, conceive, no doubt easily, whether the actuality of their realization would be as readily achieved may be a different matter, but we could readily conceive of a more muscular version of the Kyoto Convention. In similar vein, the regulation of cyberspace might appropriately be addressed in a multilateral treaty. This is the stuff of day-to-day international law. I'm less concerned with these elements of substantive lag, if you like, than I am, though, with the more systemic questions of international law. And here, by way of conclusion, I return to the 5 areas of international law, of the international legal system that I mentioned a moment ago, as requiring creative thinking: international organizational reform, reconceiving notions of jurisdiction, lawmaking and legal reform, the subjects of international law, and reconceiving sources of international law. Let me say just a very brief word about each, more as a kite-flying exercise, to throw out some thoughts that might be developed more fully another time. Looking first at international organizational reform, this has long been a focus of attention, although with less evident progress having been achieved. Myron Brilliant's remarks that I quoted at the outset in his essay leading to the discussion of the National Intelligence Council's Global Trends 2030 report go directly to the point. Let me return briefly to what he said. I quote, "The international system as we know it today and as represented by such organizations as the IMF, the World Bank, the WTO, the WHO, the OECD, the United Nations and NATO, has to reform, or the institutions at the core of the system will become marginalized and obsolete. This is undoubtedly the case, and will also be the loss to the coherence and the effectiveness of the international system if such issues are not adequately addressed. International organizations are at the vanguard of our move into the future. They need to be better enabled, to be more accountable, and to be less politicized. Issues on the reform agenda range from representation to decision-making to accountability to management. Problems of politicization are evident. On reconceiving notions of jurisdiction, as I've already suggested, our current conception of jurisdiction is overwhelmingly territorial in character, even in its non-obviously territorial dimensions. It is rooted in the analyses of the 1930s, the Harvard drafts, that have developed little since then. While the challenges of the future might continue to be squeezed into this framework with greater or lesser adequacy and effectiveness, this is not ideal. Issues of cyber, of the global environment, and of other transboundary matters could do with some creative thinking about how we approach questions of jurisdiction. Let me suggest one or two possibilities. Might there be mileage, for example, in seeking to develop a consensual approach around the notion of deemed jurisdiction, a notion that for certain forms of conduct, jurisdiction will be deemed to rest with X or Y or Z, or some configuration of all of them. What about other notions of jurisdiction? Might there be mileage in thinking creatively around other concepts? Concepts such as shared jurisdiction, overlapping jurisdiction, delegated jurisdiction, and functional jurisdiction. All of these notions move to a greater or lesser extent beyond geography and towards purpose, and in doing so may also help to move the competence that is asserted thereunder closer to the technical and away from the political. Turning to issues of lawmaking and legal reform, a matter about which Eli has written a great deal in the past. For a variety of reasons, lawmaking in the international space has become ever more cumbersome and complex. The number of independent states, with often competing political imperatives, has almost quadrupled since the establishment of the United Nations. The interaction between the international legislative space, owned by states, and the domestic implementation of states has become more tricky to navigate. What might be described as the multilateral legislative fora, the international organizations that either have an independent lawmaking competence or provide a forum for states to legislate, have proliferated, although not always accompanied by a depoliticized effectiveness and efficiency. While international law has developed flexible rules and practices around interpretation, it neither has an effective approach to legal revision and reform, nor well-developed concepts of desuetude. The result is that increasingly aged treaties and other crystallized rules of international law are often left to carry the burden of addressing conduct and of shaping an international system that may bear little relation to the conduct and system for which the rules were originally crafted. This is ultimately unsatisfactory. The pace of change in the international system over recent years has been rapid. International law will have to keep up. The issue of the subjects of international law speaks for itself. Pushing the boundaries of international legal personality has been on the active agenda of international law for more than 60 years, since the Reparations for Injuries Advisory Opinion of 1949, dealing with the personality of the United Nations. But while there has been some movement in international law, in the way in which international law conceives of individuals and corporations, this movement and the mechanisms and structures of the law in this area have not kept pace with the developments of the international system more widely. In the era of globalization 3.0, in which the principal agents of change are individuals, international law will need to develop a more sophisticated appreciation of international legal personality and of the subjecthood of international law. Turning finally to the issue of reconceiving the sources of international law. My inclination is that we know, is that what we know as traditional public international law, if it is going to maintain its relevance and effectiveness, is going to have to increasingly take account of and find ways of incorporating what is sometimes described as transnational law, the law that applies internationally to the conduct of private persons. An initiative to this end emerged years ago out of the field of transnational commercial law in the form of the Lex Mercatoria. This now has a life of its own, even if the concept has not become a fully formed feature of mainstream international law. There may, however, be scope to build on it and to combine it with more traditional appreciations of customary international law, to develop a more creative and expansive conception of sources of law that will address the circumstances and the conduct of the globalization 3.0 world. Ladies and gentlemen, let me conclude by going back to geography. There is a lovely chapter, chapter 15, in a book that I'm sure many of you will know, a childhood book, The Little Prince, in which the little prince has a conversation with an old man, a geographer. It is a chapter that is full of charm and wonder and has lovely imagery about the planet Earth, which it is said has, quote, a good reputation. The chapter also contains the following line, and I quote, "Geographies," said the geographer, "are the books which, of all the books, are most concerned with matters of consequence. They never become old-fashioned. It is very rarely that a mountain changes its position. It is very rarely that an ocean empties itself of its waters. We write of eternal things." End of quote. Geographers have a good fortune that lawyers are denied. The law is not about eternal things. It is about the here and now. It is about humankind organizes and manages its society. We hope that the law is of consequence, and it is our calling to work to this end. But the law can become old-fashioned. Mountains may only rarely change their position, and oceans only very rarely empty themselves of water. But the law is both more vulnerable and more adaptable. The place of geography in the international system is changing. It presents challenges to international law. These are the challenges to which we must all rise. Thank you very much.
Thank you very much indeed, Daniel. We've got time for a handful of questions.
I hope I stunned you all into silence.
Yes. Anybody? Any questions? Yes.
Thank you very much, Sir Daniel, for this fascinating lecture. Your last quote from The Little Prince reminded me of another quote from The Little Prince. This is the scene where the little prince meets the king. And the king sits on a small planet and reigns over that planet. The only problem is there's nobody else there to reign over. So the little prince asks the king, "What do you do?" And the king says, "I command the sun to rise every day, and I command the sun to set every day." And the lesson I've always learned from that one particular line is a wise legislator and a wise ruler has to adjust his commands to reality. Now that is one of the major problems of international law, of course. You spoke about the lack of nimbleness of international law and of international law instruments. If we look back at Westphalia, that you invoked several times, I think it is fair to say that Westphalia was the first genuine multilateral conference, yet it was a very clumsy one. In fact, the two parties didn't really meet. That's why it's called the Peace Treaty of Münster and Osnabrück. It was held in two places because the Catholics and the Protestants still hated each other or feared each other so intensely that they wouldn't even meet in one place, and they were in between, so had to go between these two places. And yet, as we all know, the outcome was momentous, and we still talk about it today. Yet, as we know, the outcome was a series of bilateral treaties. It didn't seem to occur to them that a multilateral treaty, something we take for granted today, would be more practical than a series of bilateral treaties. It took another 150 years before the concept of a multilateral treaty was invented at the Congress of Vienna. The final act of the Congress of Vienna was the first multilateral treaty ever, at least as far as I know. It took another 150 years before people started to speak of international legislation in a genuine way, namely something that transcends treaty making. I remember in I think it was in the 1960s, there was a famous article, and I must admit, I forget by whom, on the quasi-legislative power of the United Nations. You probably remember who wrote that article. Never mind, anyway. For a while, people seemed to assume that it was the General Assembly of the United Nations that would take over this legislative power. I think history has proved that particular assumption wrong, but we have different techniques almost surreptitiously invented since. I'm always fascinated by the way the ILC articles on state responsibility are treated today. It's really just articles, as the name indicates. They were adopted by the General Assembly, okay, but it's articles, it's not a treaty, it's not a binding instrument, and yet if you look at practice, everybody treats these articles, plus James Crawford's commentary on it, as if it were positive international law. In fact, tribunals routinely apply the ILC articles as positive international law. Of course, the justification for that is we say this is customary international law, but of course there's a good element of fiction with that. We just call it customary international law, and since we strongly believe it to be customary international law, it becomes customary international law. Anyway, I've spoken too long already. My point is, perhaps we should start thinking about Article 38 of the ICJ statute, and perhaps we should start thinking about new techniques. This is going to be a difficult topic, but I don't think it's entirely impossible. Thank you very much.
Thank you, Professor Schroyer. Any other questions? Yes, the lady there.
Let me also say that your talk was absolutely fascinating and very provocative. One question that I would like to ask you is, in an era where the individual as such has to be recognized, the prominent position that you suggested, how would you put that into accord with the other suggestion that you proposed, that international technical organizations have a leading role to play in our future? As you certainly know, there's a problem about the detachment of the international organizations from the individual. Their accountability their non-accountability or relative accountability also depends from the fact that they are very much linked to state bureaucracies and very detached from the individual. So how is a bridge to be designed between the need to recognize the prominent role of the individual in the era of globalization and the need to allow for technical organizations to take the lead also? Thank you.
Thank you for your interesting talk. I was just wondering, when we are considering notions such as non-territorially based jurisdiction and non-state jurisdiction, how does this impact on the concept of sovereignty?
speak now.
I'll put it on.
Christoph, I can only agree with you. As you were talking about the king and the little prince, I began to think of all the other notable monarchs and others that arise through literature and folklore, and wonder about the emperor that doesn't have any clothes and whether that is going to be relevant as well. I agree, of course, and that was the thrust of part of what I had to say, that one does need to think again about Article 38 of the Statute of the International Court of Justice and sources of law. Had there been more time, I might have perhaps been tempted to expand upon ideas around the lex mercatoria and wonder about fusing notions of lex mercatoria and customary international law into a concept that I have previously spoken about and described as, not for any particular reason, just that one needs a peg on which to hang things, as the lex congregatio, the law that will apply to society, developed on the basis of an edifice of state law, but which has elements perhaps drawn very much more from the law of the European Union about the mutual recognition of standards, about industry-wide standards, and based on a principle which would ensure, as we have now as a matter of private international law, that individuals are bound by the every time they click on the I agree, but as a global matter, as a matter of international law. So I do think that there is scope to do some creative thinking about the sources of international law and about bringing public international law and transnational law closer together. On the very interesting and important question about how do we better recognize individuals, and is that at odds with a greater role for specialized agencies and other international organizations? Well, I don't think that necessarily it is. I mean, it depends on the structure that we come up with, but one can conceive of all sorts of circumstances in which individuals are given a greater role of participation in international organizations, where you have got a congress or a conference or a plenary of an international organization which has as part of its participation individuals. One of the issues, one of the areas that Eli Lauterpacht has written about a great deal, going back to his aspects of the administration of international justice, was the place of individuals before dispute settlement bodies. And while we know that an individual can, for example, in Europe, in our space, bring proceedings before the courts in Luxembourg and the courts in Strasbourg, they can't bring proceedings before the World Trade Organization panels and appellate bodies. They can't bring proceedings before the International Court of Justice. Now, I don't raise these points flippantly with a sort of sense that these will be easy issues to remedy, but standing before courts and tribunals would be a very important indicator of a changing shape of individuals in the international system. Many states, the state that I used to represent formally, includes individuals as part of their formal delegations to many international conferences, members of NGOs. We might see more of that. The way in which we reconceive sources of law, so that it better brings in individuals, may be another way of drawing individuals more into our international system. On the question of deemed jurisdiction and sovereignty, well, I suppose that's precisely the point. It's really moving away from classical notions of sovereignty as we conceive them in a Westphalian system. And I suppose a clearer statement about sovereignty might have been in my remarks that I think that sovereignty, as previously conceived, is increasingly outmoded, and deemed jurisdiction is precisely to move beyond those outmoded notions of sovereignty. Now, of course, one can square the circle by asking the question of, well, who is it that would exercise sovereignty in a deemed jurisdiction world? So if one was to speculate about cyber, for example, and think about deemed jurisdiction, we don't know where these transactions actually take place, or rather we could identify a fixed point, a fixed geographic, real-world geographic point if one transmits an email from New York to Malaysia that goes through an internet service provider in Europe, the domestic laws of any state or of international law may say that the transaction takes place in the United States or in the United Kingdom or in Malaysia or somewhere in between. But there is a degree of artificiality about that. But it seems to me to be quite feasible and acceptable, and maybe even desirable, for the international community to get together and say that in respect of cyber activities, we will deem jurisdiction to arise in the place of origination. So in the example that I've just given, it would be the United States that would have jurisdiction. Or equally, they might say that we would deem jurisdiction to arise in the place of receipt, or anywhere else in between. So deemed jurisdiction, I think, is not a value-laden term that cuts one way or other in respect of sovereignty. It's really where the deemed jurisdiction ultimately rests. But the thesis of this paper is that I think we need to move beyond traditional notions of sovereignty.
Thank you very much indeed, Daniel, for such a thought-provoking and controversial speech. This brings us to our next event, which is a very exciting one, and I'm very excited because the artist who has done, I think, a marvelous job and has taken at least 3 months to perfect what the final product, which is unveiling of Sir Eli Lauterpacht's portrait. May I ask Monsieur Frédéric Wagman to come up here? Frederick. Sir Eli, this is in recognition of your, what shall I say, humanity, your contribution to international law, and to being a wonderful friend and mentor. May I introduce Mr. Frederick Wagemans, who is the artist who has painted this. This was painted from photos. He hasn't seen Eli Lauterpacht until today. Therefore, this could be a real surprise. Would you like to say something in French? Or if you like?
It is the best honor for me, Dr. Lauterpacht.
Yes. Shall I pull it for you? Are you sure? Yes. You're not going to have a heart attack? Going to shake hands with the artist. Shake hands with the artist. Thank you, Frederick. That's lovely. I'll just introduce you there. We are honored that Sir Eli wishes to say a few words, and after which we are going to, you will deserve refreshments. There will be a reception, drinks reception at the back of this room and in the adjacent rooms. Thank you very much.
I was about to say, behold, my likeness is brilliantly portrayed by Mr. Frederick Wagman. the more brilliantly because he never saw me before this afternoon. I thank him warmly for the excellence of his achievement in the circumstances. It will hang, this portrait, on the wall opposite Adnan's desk in his office. May my constant gaze inspire him even more in pursuing his admirable practice in Mena. How often does a man or even a woman in this now gender-conscious international law world enjoy the distinction of a pre-mortem commemoration? For that is what this is. Needless to say, I am very happy to be able to attend it myself and to have been able to hear the learned and stimulating address of my old friend and colleague, Daniel Bethlehem. I greatly appreciate the effort that he has made to come here. That this meeting takes place in Brussels also adds to my pleasure, for this is the city that I associate with one of the most significant experiences in my career, my participation in the Barcelona traction case, so long ago that I can hardly remember when. Nearly a half a century, I suspect. The principal figure in that case on behalf of Belgium was Henri Rollin, who led the team with consummate skill and charm. Soon after I joined the team, we had a meeting here at the Société Générale in Brussels, over which Rollin presided. He required all those, some dozen of us, sitting round the conference table to contribute our views. All spoke French, as I also began to do, not without hesitation. But after a few sentences, Rollin interrupted me to say, Lauterpacht, and he had a smile on his face. Lauterpacht, he said, I think it would be better if you spoke in English. It was, of course, a great case. I was required as my small contribution to attempt to pierce the corporate veil. In this process, I was confronted by another great advocate, Roberto Ago, who spoke on behalf of Spain. He adverted to the Delagoa Bay case in terms which were totally unsupportable. So when it came to my turn to respond to him, I stood before the court with a copy of the Delagoa Bay judgment in my hand. And sentence by sentence, I took the court through the text of the relevant part of that award. The court was impressed, but not Argo. In the course of his rejoinder, he said, and I will never forget this, when my young friend knows the Delagoa Bay case as well as I do, he will know not to contradict me. This was an unusual way of responding to a fairly cogent argument. A smile spread slowly across the row of normally placid judicial faces. Argo's remarks were retrieved by his team before they could appear in the record. So you'll have to believe my account. Apart from the Barcelona traction case, which reminds me of Brussels, I remember that there was in those days a splendid restaurant in Brussels called La Reine des Moules, the Queen of Mussels. Enormous portions were served out of buckets, and I have never had a chance to revisit that restaurant, but I'm told that it still exists. Reminiscence may be all very well, but not to the exclusion of other important things that I have to say. First, I repeat my thanks to Daniel. He has been very, very busy. For 5 years, he was the legal advisor of the British Foreign Office and did admirably in that role. And he has now gone on to other things which I fail as yet clearly to identify. But I must reserve my additional thanks to Adnan, who, without really consulting me, devised this idea of the lecture series in my name while I am still living. It is an imaginative and generous gesture which he has been able to arrange together with his colleague Sergei Dilevka. The visit that they have arranged has enabled me to bring my wife, Catherine, to join me here and to meet Adnan's charming wife, Amelia, and their son, Alexander. And so I come to my final recollection. It is of a story about a young Australian boy who went to his mother and he asked her, "Mum, what's fornication?" And she said, "Wherever did you hear a word like that?" And he replied, "I heard it at Aunt Lizzie's wedding." "Well, who said that?" says Mum. He said, "Uncle Tom said that. He said, fornication like this, you'd have thought they had had champagne." That's the story. And this is what I think Adnan now intends us to have. Thank you very much, Adnan.
Thank you, Eli. It remains for me to say thank you very much indeed for coming and attending this very important, or what I consider is a very important event. Please stay behind and possibly a glass of wine or a glass of orange juice and meet new colleagues and friends and old friends. Thank you very much indeed for being here tonight. Thank you.